Okay, here we go. Good morning. Let me put my bongos away and we'll get started. All right, just a quick recap of where we've been. Um, we've been arrested. The prosecuting attorney um, prepared the information, which is evidence collected against us, to present to a grand jury. Right? The grand jury, remember, is a jury of inquiry. It doesn't find you guilty or innocent. It either says, yes, there is enough evidence for you to stand trial, and if it is a yes, they hand down an indictment. If it is a no, it says, nope, not enough evidence for this person to stand trial, then that person is acquitted. Right? And if you are acquitted, you're pretty much free at that point. If yes, then you're going to be arraigned again, if you haven't been arraigned already. Maybe you'll have to go be rearrested, taken into custody, right? Because the grand jury found that there was enough information against you that you possibly committed these crimes or crime, right? The grand jury hands down an indictment, you'll be arraigned, which, remember, it means you're in front of the judge, and the judge is going to ask you how you plea. Sometimes you can plea down, right? You can plead down to a lesser charge. You say, your defense attorney will ask for a lesser charge, or maybe the prosecuting attorney will say, if you plead guilty, we'll let you plead down to this lesser charge or this less amount of time in jail. All right, whatever the case may be. If at this time, remember, you still say that you are not guilty, then the trial will begin. Okay. And the trial in a criminal trial kind of follows the same format as it does in the civil trial, right? A jury is selected. There's opening arguments, introduction of evidence, including the testimony of witnesses, closing arguments, instructions to the jury. The jury deliberates. The jury comes back with a verdict, and then the judge will impose his sentence. So it's kind of this. It is the same format as a civil trial, but there are some major differences. In a criminal trial, and this is a huge difference, in a criminal trial, you are remember, you're innocent until you're proven guilty, right? The burden of proof falls on the prosecution. The prosecution has to prove that you are guilty beyond a reasonable doubt. You can sit there and say nothing. They have to prove their case. Right? They have to prove their case. You have the right to defend yourself against their accusations and what they think is proof, but the burden of proof falls on the prosecution, because in America we are innocent until we are proven guilty. And we try to prove our innocence by calling our own witnesses and having our own evidence and things like that. But in a criminal trial, the verdict has to be unanimous. Every person on that jury has to find you guilty for you to be guilty. If there's 12 jurors and there's one or two that say, nope, not guilty, there's nothing you can say. We've been sitting in this room for hours and there's nothing you can say that's going to prove to me that we need to find this person guilty. Well, it's really in a criminal trial, it's all or nothing, right? If the jury can't come up with unanimous decision, right? All 12 say guilty, all 12 say not guilty, then there's a mistrial and another another trial will happen. A new trial will be held with a new jury. Um, so it's important. We'll talk a little bit more about juries in a second, but in a civil trial, right, in a lawsuit, it just has to be unanimous. They find in favor of, right? So if there's 9 jurors and 5 find in favor of the plaintiff and 4 find in favor of the defendant, the plaintiff wins. It's a unanimous choice. But in a criminal trial, right, it's a unanimous choice. Yeah, my laundry just buzzed. I told you I was going to be doing laundry. This is your constitutional right. It's Amendment 6 to the United States Constitution. You don't need to read it all, but it says that you have the right to a speedy and public trial by an impartial jury, jury of your peers. You also have the right to counsel, an attorney, a competent attorney. And you also have the right, if you want, to waive your a trial by jury and just have the judge decide, which doesn't happen too often, but it does happen. All right, here's some jury qualifications. In order for you to be a juror, all right, you have to be at least 18 years old. You have to have lived in that county. Remember, we're talking about a major trial here in county court, right? You have to be at least 1 year resident in that county. You have to have full possession of your mind. You have to know the English language. Okay? So if you only speak and read Spanish and you talk Spanish, you can't sit on a trial of something that's going to be all done in English, right? Also, a couple things: you can't be a felon or a convicted malfeasant, means a person who's always in trouble. More on juries. A body of laymen. Men and women who are randomly selected. We talked about before how they are selected. In the 15th century, trial by jury became the dominant mode of resolving legal issues. It replaced trial by ordeal, which means if they put you in boiling water and you survived, then you must have been innocent. You were saved by a deity of some kind, or think of the Salem witch trials, right? Where if you survived the dunking in the water or burning at the stake, then you must have been innocent. So thank goodness we don't do that anymore. In 1978, the Supreme Court ruled that juries fewer than 6 persons were unlawful. The number 6 is just too small. Too many people who can be swayed one way or the other. The right to a jury can be waived. We talked about that. And the petit jury, or sometimes petite jury, is called because it has a maximum number of 12. Typically, it is a 12-person jury with a 13th that's an alternate that sits in the case. And here's the testimonies as well. The grand jury is different than this jury, than the trial jury, right? The grand jury, it's called grand because it has more than 12 usually. Sometimes like 15 members on the grand jury, something like that. So not to be confused with the grand jury. The petit jury has 12 typically. And when we talk about a body of laymen, men and women randomly selected, it doesn't say anything about smart people. It doesn't say anything about people who are maybe have some ingrained prejudicial ideas. It's normal people. I mean, you could have somebody who is very highly intelligent on your jury is somebody who's not. It depends on those lawyers to pick a solid um, jury, but could be some could be quite a diverse group of people there um, on the intelligence spectrum of things, and the experience spectrum of things. So that's always the tough part of being on a jury and the attorney selecting a jury. A little bit more. The jury deliberates in private. Sometimes there's conversations in the courtroom where the judge will excuse the jury because the jury can't hear what the lawyers and the judge are talking about, and then they come back in. There's a room that the jurors will go sit in that's kind of private and it's just for them. When the case is over after the closing arguments, the jury will deliberate in private, and they don't have to say why they decided in one favor of the other. They just have to vote guilty or not guilty, really. After the verdict is announced, usually by a foreman, the head person of the jury. Sometimes it'll be appointed by the judge. Sometimes it'll be elected by the jury, or somebody just volunteers to be the foreman. The jury can be polled. In other words, it'll say, Mr. LePin, member number 4 of the jury, do you agree with the verdict? Yes. Next person, do you agree with the verdict? Yes. Next person, do you agree with the verdict? So that's polling the jury. And occasionally, the jury can be sequestered. What that means is, in high-profile cases, and this happened in the O.J. Simpson case, they couldn't go back home. I mean, this case lasted for months. They were holed up in a hotel someplace, and then brought to the courtroom. And the media that they were able to read, like newspapers or news on TV, that was all filtered to them so they wouldn't be biased. Because there's so much opinion out there on this particular case. The judge thinks that the person's not going to get a fair trial because of all this information out there. You're not supposed to read anything on the case that you're a juror on. So you could be sequestered, which means separated from basically society for the period of the trial until the trial's over. It does happen from time to time, but not too often. Right? Well, here it goes. Here's how we start. Arrest. And information is prepared and presented to the grand jury. The grand jury says insufficient evidence. There's an indictment. The grand jury hands down, if insufficient evidence, there's an acquittal. Right? If there is sufficient evidence, there's an indictment. You'll be arraigned. Asked how you plead. If you plead guilty, you'll be sentenced. Jail or prison, whatever your punishment is. If you plead not guilty, we go to trial. The jury hands down a verdict. Guilty. If the jury hands down guilty, you'll be sentenced. Right? If the jury hands down, the jury comes back not guilty, unanimously, both cases, right? Then, if you're O.J. Simpson, you get to go play golf and look for killers on the golf course. Anyways, that's it. Back to my bongo lessons. I hope you enjoyed these videos. I hope you're watching these videos. Let me know. All right, take care. Be safe. I miss you guys.